I always recommend you have an NDA, a confidentiality agreement in place. Inevitably, as you manufacture, as you test the product, you'll iterate. The product's going to go into version 2, version 3, and so on. And those inventions, right, those follow-on improvements need to be protected and owned by you. So that contract with the manufacturer is really important. And so for that reason, I usually recommend local business counsel drafting contracts. My team and I have developed an app that has huge potential. Love it. Please advise. We have come up with a digital solution we think can greatly help our users and customers. How do we go about patenting the app in Canada? How much should we expect to spend on it? What happens if we want to patent in the US for use as well? And patenting turns out to be too expensive at this early stage. Is there a cheaper way to secure our creation? So a lot of good questions there in that. I'm going to keep that question up just to help kind of remind me. I can't speak to Canadian law, right? I've taken and passed the US patent bar, and so I understand the US patent laws, but from what I understand in my experience, it's not all that different. If I were to give some recommendations to someone who is up in Canada, file locally. The beauty is that a lot of these patent offices are connected in terms of if you're going to go after multiple countries, you just need to file in one of those countries. That's a part of the Patent Cooperation Treaty. Most every country that you've ever heard of is a part of that treaty. And so the cool thing is you can apply to any one of those countries and they'll all reference back and point to that one examiner that you started with. The most important thing to do, of course, is to actually file a patent application, to do it right, and to use counsel to make sure that it's properly described in enough breadth and description and detail to properly cover those claims. What I will say for an app, if that's going to be too expensive for you, certainly you can go ahead and file on your own. Again, that's going to come with a big caution, making sure that you're not going to cut yourself short. So I'd always look to, if you need to take a loan out, right, pool money together with another business partner, go investor to try to hire counsel to get it filed correctly. Without filing, there's really very little protection. In the US, I will say there is a grace period, okay, a 1-year grace period that if you do go to market, let's say launch the app, you do have 1 year to then file the application, and you'll still be able to proceed forward and get the patent rights. So that 1 year can be useful if you're really stretched on money and you got to go confirm the market and you want to go test things out first. There is that grace period. And of course, that will come with the risk, of course, of some other inventor individually on their own filing the same or similar patent application. And you would be the junior in terms of being able to get the rights. So always preferable to file and use attorneys if possible. But again, before you file, I don't know if I've mentioned this yet today, but doing a patent search is critical. Making sure that what you're doing is truly unique, novel, and above anything else that's been published or patented before. So before you file, do that patent searching. Do some diligence on your own before even hiring a patent search or a patent attorney, patent law firm to do that searching for you. So why does the US allow companies to purchase patents solely for the purpose of litigation, even if there's no product associated with it? So this is a question about some of those companies that acquire patent assets and simply litigate, right? They don't actually make any products. These are also called patent trolls sometimes, and their negative connotation of those that are non-practicing entities. The beauty here is it's business, it's transactional. And so if you purchase a patent, that means that the inventor or the owner of that patent gets rewarded. They get financial compensation for bringing something new to the market, bringing something new to the technology, the field of art, and that's worth it, right? That's the whole system. Is the inventor gets rewarded financially, monetarily for bringing that new product to market. So it doesn't really matter who buys it. If their purpose is to go sue other people, go enforce the patent, that's the whole point of the system. And so you bet the US is going to allow that capitalistic cycle to continue. I have an idea for a dental product that does not exist. I need to know legally how to protect my idea and then find the means to manufacture and test the product. No idea where to start. Any help is appreciated. Okay, so a dental product, this is sort of one of those areas where it's medical in nature, medical device, or if maybe it's a product related, okay, it's going to provide some benefit health-wise. This is going to put up the initial, pointer to go have an FDA discussion, whether it's going to be a simple class 1 or a 510K. There are some certification routes that will need to be taken before you go market and sell the product if it's going to be solving some health-related, medical-related problem. Now, in terms of the patent side or the intellectual property, it's going to start right about patent research. So having done some of that yourself, if you're yourself a dental or in that industry, that's great. You'll probably already know a lot of the players in this product space. but have that done ahead of time. Then go hire a professional, go do that search, confirm, know that you're really going to have a nice broad scope of rights that you're going to go for. So taking a look before you leap, and then paying that, that big fee to hire the best attorneys you can to get that application drafted, write a solid specification, drawings, and then the claims. So in terms of the patenting, that's the process. Manufacturing and testing, that can be done once you're pending. Once you've got your patent application filed, you're going to then to be able to talk with third parties about the invention that was filed without really risk of them to be able to file anything else, because you've already beat them to it. Knowing that if you're going to get into detailed discussions with them or hire them to make something for you, I always recommend you have an NDA, a confidentiality agreement in place. Inevitably, as you manufacture, as you test the product, you'll iterate. The product's going to go into version 2, version 3, and so on. And those inventions, right, those follow-on improvements need to be protected and owned by you. So that contract with the manufacturer is really important. And so for that reason, I usually recommend local business counsel drafting contracts, and you're going to get the most sort of, protections if you have a manufacturer that's local within the same state. Or out of state would be a little more risky, and then out of the country is the most risky in terms of your intellectual property rights.